First of all, I would like to introduce myself. I am Arié Bensemhoun, the CEO of Elnet in France. Elnet is an organization that is devoted to strengthen the relation between the European countries and Israel, and also working on all the connection with the Middle East. And we are very oriented to build this close relation between Europe and Israel based on shared values, shared democratic values, and common interests. So for this new roundtable on Israel facing international law, we made a partnership with our colleague of thinc, the Hague Initiative for International Cooperation, which promotes the rule of law, fairness, international cooperation, and friendly relation between nations. I would like to thank my friend Peter Ugendorm, Director of Operation, and Andrew Tucker, the Director of Program, for the coordination of this event. Today, we will discuss the challenges and consequences of legalizing the Israeli-Palestinian conflict with two important speakers. I'm very happy to welcome Professor Laurie, Colonel David Reisner, and Dr. Dov Jacobs. The latest war between Israel and Hamas in Gaza and the recent decision of the International Criminal Court, ICC, to open an investigation in Israel and Palestinian territories have brought the century-long dispute back into the legal arena. Is Israel fight against Hamas justified under international law? That's the question we will try to answer today, tackling three issues. First, Israel-Gaza, the law of self-defense and the question of proportionality with Professor Laurie Blanc. Second, does Israel respect international law with Colonel Advocate Daniel Reisner? And third, prosecution of Israel leaders for war crimes and crimes against humanity with Dr. Dov Jacob. It's now time to give the floor to Andrew Tucker, Program Director of thinc, moderator of this seminar. We will speak about the legitimacy of Israel under international law, and will also moderate the debate, and you will have the opportunity to ask questions. You can do it through the chat that is open, and we will try to convey all your questions to our speakers. I'm sure not everybody is here, but we will begin, and the people that are scheduled to be with us today will join us. No problem with that. So please, Andrew Tucker, you have the floor to begin your intervention, please.
Thank you, Arié, so much, and good afternoon, good evening, good morning, everybody, wherever you might be. It's an honor to be joining with Elnet in this series, where we're going to look into this very complex issues about the role of international law in the situation in the Middle East generally, and we're focusing today on Hamas. Now, it's actually quite strange that we're having this conversation in a way. What in many ways should be a fairly straightforward conflict has become obfuscated and confused by actually a century of history, which has confused our understanding. And I think there's a reason for this, about how to look at these territories. My job is just to give some introductory remarks to the three speakers who will talk in their specific areas. And I want to explore the concept of legitimacy. There's a difference, obviously, between the legality of action and its legitimacy. And Israel's not fighting just a military campaign, it's fighting a war of perception. And one of the interesting things that's come out of this latest round of the conflict with Hamas is in fact, Hamas seems to be winning that international war of perception. This has triggered an outflow of very anti-Israel, anti-Jewish sentiment worldwide. even though Israel, from its perspective, and we'll hear more about that, is defending itself against indiscriminate attack by a terrorist organization on its doorstep. And the question is, how can that happen? And what does that have to do with international law? Well, when we look at legitimacy, this is a core concept in the UN Charter. What we're facing is a campaign to delegitimize the state of Israel. Now, I think there's probably only one state in the world where there is such a campaign. And the best example to compare it with in the past is obviously South Africa, with the boycott, divestment, sanctions campaign to delegitimize the apartheid regime in South Africa. And really what we've seen over the last 5-6 decades is a campaign to delegitimize the state of Israel. Now, on the one hand, Israel is a UN member state, and under the UN Charter, every state that is a member has a right to sovereign equality, which means that every state is entitled to be treated equally. It has a right to political independence. It has a right to territorial integrity, and it has an inherent right to self-defense in Article 51 of the Charter. These are all very basic UN Charter principles. We read in Article 2:4, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. And Israel is entitled to all of those rights as much as any other state. But what we're seeing is completely the opposite. So the second question is, well, why is Israel's existence so consistently and intensively being challenged and questioned? And I think we do have to go back to the history of this region. And in one minute, we'll deal with 100 years of history. But in a way, you could say the confusion was laid with the mandate system, which was intended to implement the Balfour Declaration, which was declared that the British government supported the creation of a national home for the Jewish people in Palestine. And that document, which was implemented in the mandate, which ultimately led to the creation of the State of Israel, obviously carries within it an awful lot of ambiguity and uncertainty. What is a Jewish national home? What does it mean to be in Palestine? So from day one, there was confusion, I think, about what this entity was to be and what it was to look like. And of course, from the very beginning, the Arab world, and particularly the Palestinian Arab leadership, fought with great force to oppose and to prevent the implementation of the mandate. Great Britain was required under the mandate system to enable this policy to be implemented, to enable the Jewish people to return and to settle in the land. Of course, we all know the history of how that didn't happen. In 1947, after the Second World War, the partition plan, UN partition plan of the 29th of November 1947, was adopted to try and partition Western Palestine, west of the Jordan River. Of course, Jordan had been carved out in 1921. It was part of Palestine. It was created to establish a Palestinian Arab state. And now the western part of Palestine was to be divided. That partition plan, as we all know, was rejected by the Arabs and accepted by the Jewish people. And so when the State of Israel was created in May 1948, it was created in the midst of conflict, in the very middle of a war that had already been going on for months since the rejection of the partition plan. And the very next day, the new State of Israel was attacked by the Arab world. So there have never been any well-established borders of the State of Israel. And as the decades have gone past, the 1949 armistice lines, which Israel entered into with Egypt and Jordan, particularly establishing the demarcation lines between Israel and those states, have come to be seen as some kind of frontiers or international boundaries, despite the fact that those armistice agreements say quite specifically that those lines, and in Jordan's case, and now with the Palestinians, that's the green line. It was stated clearly in the Israeli-Jordanian armistice agreement that the line was not to have any political significance as an international frontier or boundary. Nevertheless, the Arab world insisted on treating those lines, and the PLO and the PLO campaign, and we've seen this now before the ICC, has adopted what Europe also calls, and the international community calls, the pre-1967 lines, and the EU even calls them borders in its official policy, has become a kind of mantra that the UN has adopted, and now the International Criminal Court has even accepted that mantra as having some kind of legal significance. We'll come back to that, obviously, when we talk about the ICC. We don't have time to talk about what has happened since the 1967 Six-Day War, when Israel gained control of the territories that had been occupied by Egypt and Jordan. But we've seen basically a rewriting of history, I would call it. And this has taken place also within the legal institutions. And I want to mention three key moments in time, as it were, that I think are critical to understand when we think about where we are at this moment, and particularly in relation to this understanding the conflict with Hamas. Now, since really the Yom Kippur War of 1973, there has been a campaign, and it's been a very open campaign, led by the PLO, supported by the Arab League, with the Organization of Islamic Cooperation and its allied states, to campaign for the creation of Palestinian statehood. The first, I think, not the first in time, but the first I want to mention, key thing is the 2004 advisory opinion of the International Court of Justice. This was a case brought by the Arab world by having a UN General Assembly resolution passed, seeking an advisory opinion of the International Court of Justice to advise on the legality of the security barrier that Israel was constructing after the Second Intifada. And it was a terribly biased set of proceedings. We'd need another seminar to explain why that's the case. But the result is an advisory opinion in which the court made a number of statements which have been used since 2004 against Israel. One of those is that Israeli settlements are illegal. There's a kind of statement in very general terms in paragraph 120 of the opinion. Now, of course, not all Israeli settlements are illegal. Settlements are not per se illegal under international law because there is no law against settlements. There's only law against the movement, the transportation or deportation of populations into or out of occupied territories. There's no law against settlements as such. So that's a kind of term which has been used against Israel. The second one is that Israel cannot rely on its right to self-defense against Palestinian terrorism coming from the territories. And the court argues that because those threats are not coming from a third state, a foreign state, they don't fall under the UN Charter right to self-defense. This is, again, a very problematic opinion of the court. It's not a binding determination, it's only an opinion. But again, the question arises, does Israel have a legitimate right to self-defense against Hamas terror? That's a question I think Laurie will speak to later. The second point, key event of a legal nature that occurred and that is fundamental was the resolution adopted by the General Assembly 29th of November 2012, giving Palestine UN non-member observer state status in the General Assembly and within the UN. A political resolution, not binding, not intended to recognize statehood, but nevertheless has been the mechanism that Palestine, so-called, has used to accede to a whole range of multilateral treaties and instruments and organizations, one of them being the International Criminal Court under the Rome Statute. And again, I think we'll talk about that a little bit later, but that's very problematic that this political resolution has received legal validity and even to the extent of defining the territory of Palestine as the ICC has accepted it.
Andrew, your 12 minutes are over, and as you know, I am the clock keeper.
Right.
So please, we're gonna move to some questions if there are. So I'm turning to Sarah Perez. Do we have at this stage some very specific question for Andrew Tucker?
Not in the chat box, but we received some question that maybe Andrew would like to answer. Let me check. There was one question, which is it possible to prosecute Hamas by the ICC? What is the status before ICC?
Okay, so the ICC, the International Criminal Court, there has been a process since 2015. Palestine acceded to the court, became a state party to the International Criminal Court. The prosecutor of the court opened an examination of the situation in Palestine. She asked the pretrial chamber for a ruling on whether the court has jurisdiction. In February this year, the pretrial chamber decided the court has territorial jurisdiction. That is, it has the power to investigate and prosecute for war crimes, crimes against humanity in the territory of Palestine. And it's decided that the territory of Palestine is the West Bank, Gaza, and East Jerusalem. So according to the court, it can prosecute both Hamas and Israeli and any other Palestinian leaders for war crimes or war crimes against humanity, even in Gaza Strip. I think that's the technical answer to the question.
Thank you, Andrew. Sarah, we will take other questions after, and I recall that after all the debate, or all the speakers, we will have a global debate to end this conference. So please, Andrew, it's time to turn to our next speaker, Professor Laurie Blanc. Can you introduce her? And
certainly. Thank you. So we're very delighted to have Professor Laurie Blanc all the way from Atlanta, Georgia. She is a professor of international humanitarian law at the Emory Law School. And she was one of the co-authors of a submission to the International Criminal Court in the proceedings relating to whether the court has territorial jurisdiction. And obviously this question about Israel's use of force in response to Hamas firing of rockets is an issue of international humanitarian law, the law of war. And this is Professor Laurie Blanc's area of expertise. So Laurie, can I invite you to speak to us? Welcome, and thank you so much for joining us about the questions of proportionality and discrimination. And I think one of the first questions is, does Israel have a right to defend itself in the first place?
And you have 12 minutes. Thank you, Laurie.
Wonderful. Well, thank you so much for including me in this this very interesting event. Happy to join with you all. So I can give you a very short answer to that question before I dive deeper into talking a bit about proportionality and all of its complexities. But so the short answer is yes. But since I have 12 minutes, we'll dive into that a little bit more. Every state has, just like every human being has a right of self-defense. If we think about a system in which there was no right to defend yourself, the idea of being bound by that law would unfortunately go by the wayside, because everybody would decide, every person, every state would decide that the law was not sufficient to address basic needs. But let me address that more through the lens of this question of proportionality. So we tend to see the word proportionality just used for almost anything anybody wants to say about conflict, and particularly as a buzzword for any issue, any critique, any discussion of Israel's conflicts with Hamas in particular. So what does it mean when we say that, you know, Israel's operation was proportionate, or what we normally see was disproportionate? So before diving into the legal discussion, if I were to diagnose what the sort of ordinary person on the street means when they say something is proportionate or disproportionate in terms of a military operation, what they basically mean is it was about the right amount, not too much force. It seemed to be about right. Well, that's a gut reaction. That's not a standard by which we can measure or assess or plan military operations. It certainly would not give a leader, a military commander, or anybody else who was deciding in advance what is it that we can accomplish here. It doesn't provide any kind of standard. So luckily, the law actually gives us a lot of guidance on what it means when we talk about proportionality. And I think one sort of other preliminary point that's important to note here is that war is just awful, right? War is awful in no matter what situation. It doesn't matter whether it's justified. It doesn't matter whether there's a dispute about who was right in using force. The fact of war is a tragedy in every situation, right? So we're already starting, when we talk about any kind of conflict, we're in a heightened state of concern, of loss, of violence, of tragedy, which makes any conversation a bit more fraught. And so that's important to realize. But the idea of assessing the legality, and I want to come back to Andrew's word of legitimacy, which is very important. The idea of thinking about that based on a gut reaction of, well, I don't really think they needed to go that far, that's just kind of absurd. So let's talk about proportionality in two ways. The first one is in thinking about what a state can do to protect itself when it's being attacked. So in this case, Israel is being attacked, some over 4,000 rockets. I don't think it's hard to determine that rockets landing on your territory are an attack. I think by any measure, rockets exploding on your territory, causing damage, harming people, killing people, destroying things is an attack. That's pretty easy. And so the predicate for being able to respond in self-defense exists, right? But what the law says, right, what international law says is if you're going to act in self-defense, you have to meet two basic conditions. The first one is it has to be necessary, right? There has to be a necessity to act. That's good because we want to minimize the resort to war generally in the international system. It's safer for everybody that way. So you need a necessity. Well, when you have a terrorist group that is attacking you and there's no, possibility of negotiating, etc., there's a necessity to take out those rocket launchers, to take out their command structure, to make those attacks stop. The second condition is this question of proportionality. And proportionality, when you're acting in self-defense, is about the extent, how much force you can use to make those attacks go away. It's not a tit for tat. It's not a symmetry. It's about, I want to make these attacks end, so I can use the amount of force that will make that happen. When we look at the recent conflict, right, as long as Hamas's attacks are continuing into Israel, it's pretty hard to say that continuing to respond to end those attacks is disproportionate, right? You still have a need. You obviously haven't yet completed that goal. One other question that comes up here is that sometimes we see arguments that because of Iron Dome, Israel doesn't need to respond with military force to take out rocket launchers and other Hamas, Islamic Jihad, and other groups, their capabilities in Gaza. In short, I think this is somewhat of a bizarre argument, right? To say, oh, you've come up with a good defense, so you just sit here and, you know, just be a punching bag and just try to deflect everything. When we consider the fact that Israelis have to spend days and weeks in bomb shelters and everything shuts down and people are still being killed and there's still destruction and enormous amounts of disruption, that argument just doesn't hold water. I find it absurd, actually. So let's, I'm keeping an eye on time here. So in terms of self-defense, what's interesting here is that Israel's position, Israel's situation is a very clear example of why we have law allowing states to act in self-defense. You're being attacked, right? The only way to stop it is to actually destroy, degrade, disable, neutralize that capability of that adversary, and you respond in a way to do so. So why is it such an issue, right? Because obviously there's a huge debate about this. There's an enormous amount of criticism saying that Israel is not acting proportionately. Well, now we need to weave in another concept of proportionality, because what's happening in all of these conversations is that the conversation about whether Israel's overall actions are proportionate in self-defense is being driven by, infected by, complicated by another concept of proportionality. And this is the concept of proportionality in the law of war, in the law that governs how you fight. Not if you can fight, that's the question of self-defense, but how. When you're actually in a conflict, how must you conduct yourself? And here the law sets out comprehensive methodologies, principles, and rules for how parties to a conflict can conduct themselves, can conduct hostilities, with an eye to accomplishing two things, right? The protecting civilians, you know, upholding the humanitarian imperative of mitigating and minimizing suffering during war, but also recognizing and enabling the pursuit of the military objective. Those two things happen at the same time in war. Proportionality in the law of war is about minimizing harm to civilians from lawful military operations. So the question is, if there is an attack on a lawful military objective, and I'm guessing we'll get some questions about that as well. So if Israel is attacking Hamas targets, Hamas militants, Hamas capabilities, rockets, etc., it also needs to take account of any incidental harm to civilians. That's what proportionality is about. What the rule says is that when you're attacking a lawful target, if the expected harm to civilians will be excessive in relation to the anticipated military advantage gained, then you can't launch the attack. So what is that all about? That's about when you are planning or launching an attack, you have to assess, what's the value of the target? Why am I attacking it, right? What's the gain going to be? Including, well, they won't be able to use that rocket launcher to shoot at us anymore. That's a pretty significant military advantage, right? And what do I expect to be the harm to civilians in the area? And then you have to look at them. Now, proportionality is not, is my attack likely to cause harm to civilians? Is my attack likely to cause a lot of civilian casualties? Is it going to cause civilian harm that's a little bit greater than the military advantage I'm going to get? proportionality is actually a rule of excessiveness, right? The word proportionality is actually just not really appropriately descriptive. So it's a methodology. Assess the probable harm to civilians, the expected harm to civilians, assess what you're going to get as a military gain, and then consider whether the harm to civilians is going to be excessive. So how does this get manipulated in this conflict and past conflicts? Well, now we come back to the question of legitimacy. And legitimacy in most contemporary military operations is about the perception of compliance with international law. Not the actual compliance, but the perception of compliance with the law of war. And herein lies the challenge. Because what that means is that ultimately the conflict in the international space, in the international court of public opinion, is an information war. Okay, so Israel is fighting a kinetic war to stop attacks on its territory and its population.
Laurie, that you have 2 minutes to conclude.
Okay, and Hamas is fighting an information war in order to demonstrate and the delegitimization of Israel's operations, in order to chip away and damage the legitimacy of Israel's operations. So what happens? Well, we see the unfortunate and tragic use of the civilian population in Gaza for this purpose. We see the deliberate placing of military objectives in and among the civilian population. Why? Well, either to protect it from attack, because based on the methodology of the law of war, right, an attacking party must take into account possible harm to civilians, or to actually cause that harm to civilians. Because once that harm to civilians is caused, the world only sees the casualties, it sees the destruction. It doesn't see the analysis that took place in advance. It doesn't see the information about what was the military advantage. It sees the highly mediagenic, the highly tragic destruction and death. That then creates the assumption, the perception of a war crime, right? Of a violation of the law. Now, Hamas has all the ingredients it needs to engage in that information war on legitimacy.
Thank you, Laurie.
So let me tie this all together in my last few seconds.
Yeah, sure.
Okay. I said that the analysis of Israel's, whether it's acting proportionally in self-defense, ends up incorrectly being driven by this whole information discourse about the proportionality of its attacks. And what happens is that we begin to see, we see sort of extensive discussion of, well, this many people died on this side of the conflict and many, many more people died on that side of the conflict, so it must be something wrong. This is the only conflict in which we see a comparison of casualties as the measure of legality. There's nothing in the law that says there's supposed to be an equal number of casualties on both sides of a conflict. And conflicts are fought in one territory, but maybe not the other. So I think I'm out of time. I know we'll have time for questions, but to sum up, we have a lack of understanding of how the law works, a perversion of how the law works, an exploitation of that. And unfortunately, as I said, because this is really an information war, it proves very difficult to combat.
Thank you very much, Laurie. It was very interesting. Sarah, do we have some very precise questions for Laurie just after her intervention?
I have one question, which also has come up earlier, Arié, for you, Laurie. That is, clearly, Israel is not just fighting against Hamas. Hamas is allied with Iran. You know, it's now well known Iran has been providing weapons directly. It's been financing Hamas. This has been prepared for a long time. and it's not only Hamas, and there's also the question of Hamas's fight with Fatah within the PLO. In assessing the threat, to what extent is that international context something that should be looked at? Because surely, part of the thing is Israel realizes that whatever happens next, Iran is going to keep being weaponized and supported and resourced. So it's part of Israel's fight regionally against threats against it. Is that relevant?
I think it's certainly relevant, right? How it's relevant, I think depends on the particular analysis that is taking place. And so there was a fair amount of discussion in the news about this operation, about what was Israel trying to achieve on this particular round. And it was trying, most of the accounts would describe an effort to sufficiently degrade Hamas's capabilities so that it would set Hamas back X number of years, which would produce ideally some similar X number of years of quiet, right? Now, if in fact that open source information is correct, of course I have no ability, I'm just working with what we read in the news, but if that's the lens through which we're thinking about this, then Iran's involvement, Iran's commitment, capability, access, etc., to rebuild, to enhance Hamas's capabilities, restock, etc., certainly is relevant in that analysis of what is, again, necessary and proportionate to repel or deter. Those are the words from international law: repel or deter this attack that Israel is responding to in self-defense, right? Understanding what you need to do, how the extent of force that is both necessary and appropriate to satisfactorily defend yourself, depends on understanding the source of that attack, the extent of the attacker's capability, motive, intent, etc. So it's relevant, right? It's often useful when thinking about these conflicts to remember that international law exists outside of the Israel-Hamas conflict, right? Because, and if we take the names out, we can sometimes think more, we can have a more rational discussion about international law. If you imagine a country that is being attacked by what appears to be a small actor, then if in isolation, you might say, oh, well, you only need a kind of a small punch back to take care of that threat. But let's say that information is not correct, and that small actor is a proxy for a big, angry, scary, powerful actor. Now you might need a bigger punch, right? I mean, that's essentially how how in a quick sense to think about your question. There's lots of other pieces of how Iran might be relevant. Is it a party to the conflict? Is it, and so on and so forth. But as a matter of self-defense, it is relevant in understanding what is considered necessary and proportionate in responding in self-defense.
Yes. Thank you very much, Laurie. It's time to move to our next speaker. And please, Andrew, can you introduce Colonel Daniel Reisner? Thank you very much, Laurie. We will come back to you later in the general debate.
Good. So Daniel Reisner is joining us from Israel. He was the legal advisor to the IDF for many years, the Israeli Defense Forces, on international law issues. He's been very involved for over 20 years in Israeli-Palestinian negotiations and discussions. He's been part of the negotiation team of several agreements. And so he's going to speak to us about how does the IDF in particular, but perhaps Israel more generally, look at applying and complying with these aspects of international law. Daniel, thank you for joining us.
Thank you, Andrew, and thank you for Elnet and thinc for inviting me. I thought I'd divide my comments into three with your permission. First, I want to say a few short words about the background to the current round of violence, because one of the things I encounter in many of my interviews, especially in the media, is that people tend either not to remember or to intentionally forget how this round of violence started. So if you were to ask someone in the street, why was there a round of violence between Hamas and Israel a few weeks ago, many people would say it's because Israel did something wrong in Gaza, or Israel is the occupier of Gaza, or something of that nature. And while that has been the excuse of Hamas in the past, I would point out 2 points on that. First, if you actually look at the map of Gaza, you will see that after Israel left Gaza entirely in 2005, Israel is not within Gaza. So you have Israel to the north of Gaza, and you have Egypt to the south of Gaza. And when the Palestinians, the Hamas particularly, keep saying we are occupied, they don't mean that there's anyone in their territory. There's no one in their territory. It means that the neighbors to the north and the neighbors to the south don't like them. And for them, that is a significant excuse to justify trying to kill people, which international law does not allow, but also international logic does not allow. But put that aside for a moment. In the last round of violence, that wasn't even the argument. Hamas actually went public and said the following. They said, there are things going on in Jerusalem between Israelis and Palestinians, and we have a position on that. And if Israel does A, B, and C, we will fire rockets against Israeli civilians in Israel to prove our point. In other words, this is an extortion racket. If you do not accept our political position with respect to a dispute, which is frankly between us and the Palestinian Authority in the West Bank, then we'll try and kill you. And when Israel, I think justifiably disregarded the threat, they started firing hundreds and later thousands of rockets against civilian towns, villages in Israel. So I say that because this is a case of an extortionist threatening to kill you if you don't do something they want. And now Israel is being blamed for hitting back at the extortionist after they tried to kill us, which I think when you put that in context, it makes a lot of the criticism seem rather weird. The second point I wanted to address is the question which you, Andrew, have posed to me, which is what is the process within the IDF to address the concepts that Laurie just so eloquently described? And as you mentioned, I spent 20 years of my career as head of international law for the Israeli military, and I was actually personally responsible for setting up these mechanisms. But before I explain what they are, I want to explain that before you launch a military attack, you actually go through a 3-test process. Stage number 1 is the attack has to make sense. In other words, it has to be militarily justifiable. It has to achieve a military objective. You don't fire a weapon system just for the heck of it. It has to have some military advantage associated with it. And that is actually a more strict test than one would think, because you need to verify that the attack that you are contemplating actually makes sense in the scheme of the operation you're looking at right now. It's not just random shooting. And that's got nothing to do with lawyers or anything else. This is an operational test, but it is a very important test. The second test, and I can tell you this test is used more often than one would think. It has to be something which we would view as moral. Now, if you think the legal questions are difficult, obviously the moral questions are even more difficult. How do you define morality in combat? I can tell you that when I was serving in the army, I found a relatively easy test to use. And it's simple. I wouldn't approve something if I couldn't live with myself for having been a part of it. If I couldn't sleep at night after I did that. And it's a test which I cannot quantify, but funnily enough, it's more easy to use than one would think. If it's something that you are unsure if you're going to be happy with yourself afterwards, it's probably not something you want to do. Only after you pass the test of military, it has to make military sense, and it has to be moral, you actually hit the legal question. Is it a lawful attack? And to follow on in Laurie's footsteps, there are three questions you have to ask as a military lawyer. One is the target a legitimate target? And a legitimate target is generally a military objective, whether if it's a military individual or a military facility or base, whatever. Secondly, are you using lawful weapon systems? In the case of the IDF, all the weapon systems being used are lawful, so that question does not arise as often. And the third question is the laws of war proportionality question, which Laurie presented earlier. Are the expected civilian casualties excessive in relation to the anticipated military advantage? Now, there's a big question of who has to make all of these determinations in warfare. Because many people have the benefit of hindsight. People who read about wars, study wars, but haven't fought in any of them, don't remember that you have to make these decisions in real time on the basis of the information available to you at that time. So what we did in the IDF, we set up a procedure whereby the authorized military commanders, together with professionally trained, qualified international lawyers, make these determinations together. And the IDF targeting cells include targeting officers, bomb damage assessment experts who can try and give you a picture of what is the expected, what we call collateral damage of the attack, and qualified expert lawyers who will try to apply the principle of proportionality to make sure that it makes sense. And that mechanism, which I put in place about 20 years ago, is running today. There are dozens of lawyers who do that in wartime with the military commanders. IDF lawyers are deployed from the division level and above for these purposes. So General Headquarters, Air Force Headquarters, Special Forces Headquarters, and the relevant division commanders. All of them are given on the ground legal advice with respect to each and every operation and or attack. Now, I want to put this in context. Does anyone think that Hamas has lawyers advising them about the legality of the rocket attacks against Tel Aviv or Ashdod or Ashkelon? I hope not, because otherwise those people are quite negligent in the legal profession. So I know they don't. In fact, they are intentionally targeting civilians. So one of the things which some people call the reverse asymmetry of the situation. Most people always refer to the asymmetry of the big Israel versus the small Hamas. In our case, it's the opposite asymmetry. Israel making every single effort to avoid anything which would be a violation of international law, and Hamas making every effort to violate every rule of international law intentionally, willfully, and wantonly. So with this asymmetry in mind, I wanted to move to the third point. And Andrew, I think you, in our pre-conference email exchanges, you said, what will be the consequence of the Israeli army's decision-making process and potentially its after-the-fact investigation process, which I haven't touched upon yet, with respect to the potential ICC investigation. So that would be my third and final point. First of all, the IDF, as most modern serious armies, after every incident in which there is an allegation of something wrong, launches an after-the-fact investigation. In most cases, those will be what we call operational investigations. Commanders will investigate the situation to find out, did something go wrong? And if so, why? In extreme cases, where there is a risk that international law has been violated, if such an event occurred, then the investigation will be transferred to the legal authorities for what we call a legal investigation. So, for example, and this is not relevant to the recent conflict, if there was an allegation of anyone intentionally shooting at a civilian, for example, which is what Hamas was doing, but the IDF never did, then the IDF would launch actually a military criminal investigation into that allegation to find out if that happened, and if so, who was responsible. Now, I say that because the ICC is based on the principle of complementarity. In other words, the ICC is supposed to be a complementary source of jurisdiction, not the primary one. The primary source is still supposed to be national criminal justice. So, because the IDF does investigate allegations of wrongdoing, there is a very powerful argument to be made if and when it becomes relevant that the court should not have jurisdiction over events related to the IDF, because the IDF has a very robust internal investigation mechanism. However, to be fair, that is for the future, because I assume that argument will be raised if and when the prosecutor decides to pursue specific cases. And secondly, it has been made public that the prosecutor sent a letter to the Israeli government with respect to the intention to launch an investigation, and the Israeli government did not avail itself of the opportunity to claim complementarity at that stage, because it did not wish to be seen as collaborating with what it views as unlawful and unjustified legal process. I want to end with two small points. Point number one is, one of the mistakes quite often made by the media is that they assess everything on the basis of publicly available information. I'll give you one example. The famous IDF strike on the tower in Gaza, in which the AP and other international media were stationed. I was asked after that strike, I was interviewed by the Association of Foreign Journalists in Israel. And of course, this was number one on the list. Why did the IDF attack the building where we were stationed in Gaza? And I said I actually talked to the IDF before that, and the IDF had perfectly credible and multiple source verified evidence that that building was being used for highly sensitive purposes by Hamas. It was later published by the IDF themselves that part of those activities were attempts to create anti-Iron Dome blocking mechanisms from Gaza. So let me make it clear. Hamas was trying to develop an electronic capability to prevent Israel from shooting down its rockets so that it could kill more innocent civilian men, women, and children. Okay,
Daniel, you have to conclude.
Okay, so on the basis of that information, the IDF gave a 12-hour advance notice to everyone in that building, including the Hamas people who used it for that purpose, to leave the building. Now, I need to tell you that in warfare, giving 12 hours advance notice to the other side is not recommended practice. It's not legally required either. Israel does that because of exactly what Arié said at the beginning of this session. It does it because of the problem of perception, not because of legality. Because at the end of the day, today, we are fighting two battles in parallel, on the battlefield and in the public opinion. And Israel is sacrificing a lot of its legal military capabilities in order to be able to ensure that it can show everyone what it is doing. But that does not stop people from making determinations on the basis of lack of information because of the personal or political or other bias. I will stop here, Arié, and I will take any questions.
Thank you. I think that at this stage, we don't have any specific question for you. So we will have more during the debate that will be just after the intervention of Dr. Dov Jacobs. And please, Andrew, can you introduce our last speaker? And then we will go to the global debate. And for sure, the panelists could speak one to each other to respond if they would like to do it about what everyone said. Thank you very much. So please, Andrew, introduce our next speaker.
Good. Dr. Dov Jacobs, joining us from The Hague in the Netherlands, is an international criminal defense lawyer at the International Criminal Court and other international criminal institutions. He's been involved in many situations and cases, working as an amicus curiae, a friend of the court in relation to the Afghanistan case and the Palestine situation. So he has a wide experience. And he's going to explore with us the implications of this ICC process, this case, this situation of Palestine, and what it means also for this latest round of conflict. Dov, thank you so much for joining us.
Thank you, Andrew, and thank you to Elnet and thinc for inviting me. It's a pleasure to be here. Actually, I would be tempted to relinquish some of my time to hear Daniel present more, case studies of proportionality and Laurie to analyze them, because I find it fascinating, and we don't hear enough about that, whereas probably we hear way too much about the ICC, but we can come back to that later. So I have to start with the usual caveat, which is despite my many functions, I'm talking in my personal capacity here. So it's quite a broad topic, which I'm meant to discuss, the ICC. We could, as Andrew said before, it could take up many seminars. I'm just going to give a few pointers, a few elements for the discussion, which have already been addressed in part by Andrew in his introduction and Laurie and Daniel. But actually, and we did not coordinate that, but I had planned to start with a few words on legitimacy as well. It seems to be the word of the day, Andrew. Because you were right to point out that there is a legitimacy battle going on, and I think it's really fundamental to understand how that plays out at the ICC. Because the ICC, beyond being a legal process, is a question of narrative and is a question of production of legitimacy. It's a court of law, and as any court of law, it produces legitimacy and also illegitimacy. And in this sense, it is it is important to keep that in mind when addressing the relationship between different parties inside the court, different actors in relation to the court, and also to understand that this is something which is inherent in any judicial process, and especially inherent in any international judicial process. And in this sense, it's not specific to Israel. Let's be very clear. The ICC produces legitimacy and illegitimacy in every case it addresses, in every situation it touches upon. And it's irrespective of whether there is a desire or a conscious desire to do that. I hear a lot, and this is a debate I've had with a number of you over the years, on whether the office of the prosecutor is specifically choosing sides or privileging a narrative over another. And that might be true, but that's not the point. Even a purely impartial, independent, objective investigation will produce legitimacy and illegitimacy. Will construct a narrative that can be used by people outside the court. Whatever, even if it's the highest, best quality investigation, prosecutor, defense that you can imagine, you will still be able to say that, because again, this is inherent to the system. I think that's a very important point to make. One difference that you have with Israel, and again, that goes back to Andrew's point at the beginning, is that the allegations which are made against Israel, especially those in relation to settlements, are an existential threat to Israel. When in other situations, allegations can construct a narrative against a government, against a rebel group, there are very few situations at the court where the allegations actually can constitute the base of an existential threat to the state of Israel. By putting in doubt its right to live and exist on that territory. So in that sense, it is a very big difference. Now, a question that also has been in discussion since for many years now in relation to ICC, does that mean that the ICC should be ignored? Does that threat that ICC constitutes to Israel by the simple fact of allegations being brought to it means that you have to ignore the ICC? Now, there are many people who have different views on this. Again, speaking in my personal capacity, I've always believed that you shouldn't ignore the ICC, because it's a lose-lose situation. It doesn't mean you have to, agree with it. It doesn't mean that by answering it that you're giving it legitimacy. It means that you're abandoning the battlefield. the ICC will produce illegitimacy against Israel, if nobody goes there. The starting point is that it's going to be used by outside actors to delegitimize Israel. And I think that there is more to gain by intelligently, strategically interacting with the court than to just abandoning the battlefield to those who want to use the court against Israel. But that's a broader discussion we can have. Now, 3 general points I want to make about ICC and Israel. Now, the first one, obviously, and everybody knows, Andrew mentioned it, the pretrial chamber issued a decision on the 5th of February 2021, where it said that the prosecutor could exercise jurisdiction on the territory of Palestine, which it recognized as East Jerusalem, West Bank, and Gaza. Now, I won't go into the detail here about the criticism against that decision. It's mostly weak legal basis. It's over-reliance on UN, non-binding resolutions. It's kind of probably, inconsistent use of principles of law. On the one hand, saying that it doesn't deal with international law. On the other hand, referring to self-determination. It's complete ignorance of Oslo. There's a lot to be said about this decision. A lot has been said. But the reality is that today, the prosecutor opened investigation in the situation based on that decision. And I know this was one of the questions. The recent events do fall within the scope of that investigation. I think that there is little doubt that, should the prosecutor decide to investigate what happened recently with Hamas, that there would not be, for example, a requirement to, extend the investigation or to announce anything. It's just part of it at this point. The fact that there is a decision last February does not mean that the territorial issue is finished. I think that's very important to stress. The pretrial chamber issued, again, not so convincing decision. It was very careful to say that it's for just at this stage of the proceedings that this decision is applying. And I think that to believe that there's a territorial issue is not a live issue would be a mistake. And I think that in the logic of pushing Israeli interests at the court, it's important to put it back on the table whenever possible, because you're punching holes in what is a weak decision. And honestly, in relation to my point before about interacting with the court, I truly believe that the decision is weaker because so many amicus intervened. So my amicus pushed the court to issue a bad decision, to stay away from certain issues, which it might have gone into, like settlements. The prosecutor was relying a lot on settlements to justify jurisdiction, and the PTC stayed away from that. So I do believe that the decision is weak because those who intervene before the court, force the judges to make mistakes. That's what you do when you intervene. And to answer a question which Andrew has already answered, in that respect, Hamas individuals would, of course, be liable to be prosecuted based on that decision and that investigation. So that was the first point, the relationship between the decision in February and the investigation. The second point is the question of the crimes. Again, I don't want to go in the detail of the list of crimes which both sides would allege against the other side. Just one general comment which arises from what Laurie and Daniel said is a criminal trial is not a human rights report. And as a defense lawyer, I've been confronted time and again with the prosecutor bringing in a human rights report, a UN report, in order to found his allegations. But it's not the same type, it's not the same quality of evidence. And this is something which would be a battle at the ICC time and again. And again, I take the example from Daniel, where you only have publicly available information. And publicly available information will mostly say how many civilians died, possibly. And even that would be in doubt. We've seen enough examples where there are allegations that civilians died and they might happen to be combatants, etc. So publicly available information gives a very bad picture of the situation generally. And even less of a good picture and a credible picture in the context of a criminal investigation. And the bottom line is, it's really difficult to prove an international crime in theory. It should be, because you have to go into the facts, you have to go into contextual elements, you have to go into the intent of the alleged perpetrators. You have a very high standard beyond reasonable doubt. You have, you need corroboration. You can't rely on hearsay. I mean, the basic rules of criminal law normally require a very high standard, and international crime should be hard to prove. And this is where it's interesting, again, to draw the link, and it seems we're all on the same page. The disconnect between the discourse, public discourse on international criminal law, and the reality of what an international criminal trial requires. It's like Laurie said about, you're just comparing numbers in order to claim that there is a war crime. And the same way, sorry?
2 minutes to conclude.
Thank you, Arié. It's the same in an international criminal law setting. We have the same phenomenon. You have a human rights report saying, we believe a crime against humanity occurred or war crimes occurred. But in fact, when you look at the evidence, it's not that simple. So there is this complete disconnect between the two. But in that case, as a defense, the rules are protecting you. There are rules of due process, there are rules of evidence, there is a presumption of innocence, which are meant to protect you. And if you're, if strategically using them, you can draw something out of it. My final point, and I'll conclude on that, is the question of immunities. So this is one of my preferred topics, but obviously the International Criminal Court last year, 2 years ago, issued an appeals judgment on the question of immunities of heads of state of non-state parties, so in the case of Bashir. And obviously this is very relevant because the prosecution of individuals, officials of a state, requires arrests and surrender. And so, if the prosecutor were to move forward with arrest warrants of any type, we would need to revisit, and there are strong arguments against the case law at the ICC and things to be done domestically to push back against any indication that Israeli officials would not benefit from immunities when they would be under ICC investigation. I see my time is up, and I'm happy to take any questions on all those issues.
Thank you very much. It's time now to the global debate and the global Q&A. So I will turn first to Sarah to see if from our audience we have some questions. Sarah?
Yes, we will start with 2 general questions. First, what do you think are the actual chances the new ICC prosecutor will truly go ahead with an indictment or even a full investigation into settlement activity? First question. And another question, can the ICC's decision on jurisdiction be overturned in any possible forthcoming future proceedings?
Who want to answer?
Well, I think certainly the second question, that's a Dov question.
Sure.
If I could just kick off on the settlements, and Dov, you can correct me if I'm wrong, but I think the prosecutor has announced that she is opening and has opened an investigation into the crimes that she has identified in the Palestinian territories, including the West Bank. And one of those crimes is the so-called crime of settlement policies. So my understanding is she's made the decision, which is not to say that her successor, there will be a new prosecutor this month coming into office to replace the existing prosecutor. He will make up his own mind, I assume. But that investigation has been opened into crimes, including what she believes to be the crime of Israel's settlement policies. But perhaps, Daniel, you might have some more inside information on that.
Inside information about where the prosecutor is headed, I do not have, but I have some outside information about the question. there has been a lot of pressure placed on the prosecutor to move forward with the so-called Palestine, the existing prosecutor, to move forward with the Palestine investigation. And that pressure came from all of the pro-Palestinian and Arab countries. The prosecutor was amenable to that approach, and she proved it. And if you compare the prosecutor's answers on why she decided to so quickly decree the launch of the investigation on Palestine, while at the same time saying that the court does not have the bandwidth to deal with other, frankly, clearer investigations in other jurisdictions, is for me a clear indication of either bias or agenda. But that's just me. The new prosecutor is coming into a court which suffers from a variety of problems. A horrible reputation amongst international law experts. The professionalism of the ICC prosecutor's office is seriously in doubt amongst professional international lawyers. And because this is the most important criminal court in the world, that is not a situation that anyone should live with. And I think the biggest challenge for the prosecutor is to try to rebuild international confidence in the prosecuting team. And that is a huge challenge, irrespective of specific cases. After that, the prosecutor has to look at the table that Madame Bensouda will leave him, and he will need to prioritize on the basis of legal merit and making optimal use of the time of the prosecution of the court. And all of those things will take place only after he starts working later this month. So we don't know what he will decide. There is a lot of justification, substantive justification, for him to rethink the Bensouda decision if he wants to. He could also decide on the basis of administrative reasons to put this aside for now, because there are so many other pressing things on his agenda. And we definitely do not know what he's thinking about, but we know he has a lot on his plate.
Thank you, Daniel. Maybe the second question, and I've forgotten what it was, but Dov, you might remember what the second question
Sure.
was.
I mean, it's linked to it was a question about overturn the decision, but if I may, on the first question also, I think it's important to realize the process, because Palestine, as a state party, recognized as a state party to the ICC, referred the situation to the prosecutor. The decision in February is not an authorization to open investigation. We have to be very clear about that. There has been no judicial assessment so far of the prosecutor's reasons in terms of crimes committed, alleged crimes. There's been no judicial assessment of the prosecutor's reasons to move forward. And that's a major difference with other situations under which are called under Article 15, where the prosecutor decides, it's called proprio motu, on her own will to move forward, and judges have to say, I authorize you to. You have shown me sufficient evidence that such and such crime might have been committed, that some people might be responsible, etc. So it doesn't. That's in relation to the settlements issue. The fact that she mentions, Fatou Bensouda mentions settlements in her request is incidental. It was not legally required. This is not the object of her request, and it means that judges, so far have not given any opinion about this kind of claim. That's one thing I wanted to clarify. In terms of overturning the decision, there is no appeal. So technically, that specific decision will not be overturned. Now, can it be revisited? I believe it can. It can be revisited either directly with a new composition of a chamber at a later stage, expressing a view, but it can also be revisited based on the fact that the decision itself says this is only a temporary decision. It's only applies at this stage of the proceedings, which means that when there is a challenge at a later stage by an accused or by, a state, Israel, unlikely, but possible in theory, there is nothing preventing a state or an individual from reopening the discussion in relation to that decision. To keep the answer short.
Thank you.
Thank you very much. We have another question from the audience. Sarah, please.
Yes. To what extent do modern conflicts like the one we saw recently in Gaza continue to shape international law? And to what extent this kind of dense urban war zone present new challenges to governments?
Laurie, is this maybe a question for you? To what
Sure.
extent does conflicts like Gaza influence or inform the development of international humanitarian law?
I think they do significantly, and in ways that often are not desirable or anticipated. So what we see if you think back to war before there was television, right? A country sent its forces off to war. Maybe soldiers wrote letters home. There were war reporters, but information kind of trickled out to the public at a very measured pace, very stately pace. Then we have the advent of television. We have reporting on television. Then we have the 1991 Gulf War, where we have CNN broadcasting 24 hours a day from the conflict. That's all just a backdrop to what we have now, where we have instantaneous information, whether it's right or not, but we have instantaneous information flooding the airwaves, flooding social media about conflict. That's happening about a number of conflicts. It happens to the extreme with respect to any conflict that Israel is involved in, for any number of reasons, right? That could be a whole nother hour and a half conversation or more. So what happens is that the discourse about war is happening in real time, too fast for accurate information. I should say, paralleling that is that in the last 20 years or so, maybe 20, well, let's say 27 or 28 years since the breaking of the news story about concentration camps in Bosnia in about 1992, 1993, all of a sudden the language of international law, the language of war crimes and international humanitarian law has been introduced into the public discourse, right? You didn't see that much news reporting use the language of the law before that. So now what we have is a public discourse with the injection of legal terminology, which is a very sophisticated body of law, right? Being dropped into a very fast-moving public discourse without the necessary information. If that doesn't sound like a recipe for problems, then maybe I didn't explain it well enough. But what we have is that every conflict affects the development of international law and the evolution and the interpretation of the law, because every conflict involves new things, right? Even if they're not actual new technologies, just literally some different tactics, different facts, different parties. It's all relevant, right? Law develops organically in addition to in the formality of treaties. But when we have this discourse, which is entirely based on media reporting, lack of complete information and perception, and the desire to reach immediate conclusions, because, particularly Americans, we like to, just say win, lose, yes, no, right? We're not very good at gray. We're all black and white here on this side of the pond. So what you then have is this rush to international law-ize the conflict. So to take the example that Daniel mentioned of the tower in Gaza that housed both the media offices and a host of Hamas capabilities, what the world sees is a 12 or 13-story tower in Gaza reduced to rubble. It then immediately is told that the AP and I can't remember who else had offices there. that based on that, everybody's up in arms. Well, it must be unlawful. I mean, obviously, right? That's the immediate reaction, because we don't have any information other than the visual. We don't have any information other than effects. And so one of the challenges that current conflicts pose is the constant introduction of what we would call an effects-based analysis of the law, trying to determine legality based on what you see physically, right? The visual effects. But that's not how the law works, right? The law does not base legality on effects. It bases it on process, on intent, on prospective analysis, on reasonableness, on all the component parts that Daniel was talking about, that I mentioned a little bit with proportionality. And so we're seeing really, depending on, you know, how strongly you feel about it, either a problem or an insidious problem, in which lots of people want to talk about the law, but they don't have the tools, either the legal tools or the facts, to do that. And that creates a big problem, because as a last piece of this, I'll just note that it's actually very easy to say that's a war crime. I mean, to say it, not to prove it. Dov is right, hard to prove. It's easy to just be like, oh my gosh, 27 people died, war crime. Doesn't require a lot of analysis, a lot of nuance or anything. It's a lot harder to say, yes, 27 people died. That is a tragedy, but let's dive into how that happened and who did what and how they acted and what their decisions were and what the law says about it. That takes minutes, hours, days, weeks. The people died, it's a war crime is instantaneous. And once it's said, it's really hard to walk back. And so that's been a big effect on the development of international law, is essentially trying to deal with this effects-based analysis, which incentivizes groups to use human shields, to misuse protected areas, because it's a windfall for them, right? They just create effects. And everybody assumes those effects are then an answer under the law.
Thank you, Laurie.
It wasn't very uplifting, but.
Thank you, Laurie. I have one question for each of you. I will begin with you, Daniel. A short question, please answer maximum 2 minutes if you can. Can we say that the war of independence declared by the Arab states against Israel in 1948 is the mother of all violations of international law in the conflict in the Middle East? I ask this question because we always hear that Israel is not going through the international law, and it's something that we should, this question should be addressed. So what about my question, Daniel?
When I teach classes on the history of the Arab-Israeli conflict, one of the first questions I ask the students, so when should I start? Some like to choose 1967. Some like to choose 1948. Some prefer to choose World War I and the demise of the Ottoman Empire. Others choose the beginning of Jewish emigration from Europe at the end of the 19th century. And others say, go to the Bible and you'll find your answer there. And there are as many answers in between that you can hope for. I am not a believer in the starting date for this conflict. But the problem is that people keep asking who is to blame. And there is an assumption that one side is to blame and the other is blameless. And there's an assumption that one side is the one who started everything and the other side is the one who had to respond. Unfortunately, life is much more complicated than that. And the reality is that, and I spent 20 years of my life as a negotiator with the Palestinians. Arafat was invited to my wedding. So you need to understand that I know the other side well, both from the combat side and from the negotiating table. I want to be fair, Arié. I think the question is wrong. I don't care when it started. I don't care who shot the first shot. if it's the Arabs or if it's this one. I want to end it. However, until we end it, we have to make sure that all sides comply with the rules applicable to warfare, because we are at war. And the problem is that we do our utmost and our best to comply, and the other side does not care. And yet, in spite of everything I just said, the world looks at this and says, somehow, what you say, that Israel is not in compliance. Now, this is either intentional blindness or just not asking the right questions. But for me, who is to blame? When did it start? That is, I leave that for the people who want to keep fighting for another 2,000 years.
My question was not exactly when that it started.
I understand.
Was it a breach in the international law to declare war against another country?
So, after World War II, it was decided to delegitimize international aggression. And one of the biggest criticisms against the Nuremberg war trials, and I think a justifiable criticism, is that some of the Germans were prosecuted for crimes which did not exist until the Nuremberg tribunal was put in place, which is a real problem for an international lawyer. But today, the international crime of aggression is even part of the International Criminal Court statute. So there appears to have been a lot of progress since 1945 in the delegitimization of attacking another country. You are asking me if it was a violation of international law for the Egyptians, the Iraqis, the Moroccans, the Saudi Arabians, the Jordanians, the Lebanese, and the Syrians to attack the newly declared state of Israel in 1948. I will claim yes, but I've heard them say no. And to be fair, I don't think there's any way we can have a real adjudication of the legality of that event today in 2021, although I am with you. I think it was illegal use of force to try to resolve a political problem. But as I said earlier, I'm not a great believer in using that as a solution.
I agree with you. It was just a question. So my second question is for Dov Jacobs. Dov, there are dozens of armed conflicts in the world, and some of them where countries like France, United States, UK are involved. And we, the Jews and Israelis, are the only ones to question the proportionality or the conformity of our action with international law. What does this say about the world where we live and how international law is viewed or interpreted?
Okay. How long do we have left?
You have 2 minutes.
Yeah. There's a lot of elements in the question. Now, every one of you has, highlighted, and it would be blind not to do so, the disproportionate attention that this conflict gets in the media, in public opinion, at the UN, especially in the past, 15, 20, 30 years, whenever you want to start counting, as Daniel says. This does not mean that other situations don't get some attention. The ICC has been functioning for the past 20 years without the Palestine situation, with its problems and difficulties. It does not mean that human rights reports are not written about Tibet, and I'm not going to list places, but other places in the world. So the problem with this discussion, and this, I'm not reacting here as a lawyer, it's just a question, is to fall in the other extreme. Is to think that nothing else gets any attention, or, and this is not for me to say, that Israel and Palestine should get none. I don't think anybody's claiming that. So, I don't want to sound like Daniel putting away the question. I think it's really important to address this, imbalance in the perception of Israel. But I think as lawyers, our job, and this is what we've done today, is to be as competent and professional as possible in presenting the law, in analyzing the facts. And I know it's difficult to use that term in such a conflict, in a dispassionate way. Laurie used the word rational conversation. And it's often impossible to have a rational conversation about this conflict. So that's all I would say in my humble position. I'm not the Secretary General of the UN, so I cannot reform. I don't think, to answer simply, Arié, I don't think we should throw the baby of international law with the bathwater. Definitely. The conclusion of that discussion cannot be that international law is pointless, is biased, is all political, and that we should throw it away. But that we can develop that in the next seminar.
Thank you very much. So my last question for you, Laurie. Have you read that article published in the Washington Post, which says that the success of the Iron Dome is contribute to the perpetuation of the conflict because it avoids pressure on Israel? What do you think about this statement and the way the people see the right of self-defense when it's about Israel?
So I think if I did see that article, and I think if I'm remembering correctly, I think what it was getting at is that Iron Dome has, by enabling Israelis to live with more security, has thus maybe slightly dulled their feeling of an imperative to more substantially resolve the threat that Hamas poses. I know I said that a lot like a lawyer. I kind of couched all of that. I won't speak for how Israelis feel. I haven't been there during the rockets being fired during the most recent conflict. So I don't presume to speak for how someone feels about the threat of rockets and the danger to them and their families. So I can't comment on that. But I think so. Let me come at the Iron Dome question a little bit differently. First of all, there's the point I made earlier, which is that some people use Iron Dome as a cudgel to say, oh, well, Israel, you actually can't take offensive action in self-defense because you have this extraordinary defensive capability. Again, I think that's absurd. I think to suggest that you have no right to actually eliminate, let's just take a rocket launcher. Simple thing, not even getting into the rest of Hamas's capability, that you don't have the right to actually disable or destroy a rocket launcher, because instead you can wait till the rocket is launched and then use your high-tech capability to shoot it down out of the sky. I got to tell you, I can't come up with any other country, any other scenario in which that argument would be made with a straight face. I don't see any basis for that argument. It, to me, is based on sort of, again, delegitimizing a right of self-defense. Iron Dome is also important for one other thing that we haven't brought up, which is the obligation of a country or a governing actor, because Hamas governs in Gaza without getting into the status of it under international law. It is responsible there. The law of war places responsibility and obligation on a party to a conflict to protect its own civilians, to take precautions as the defending party, not only to take the precautions that Daniel was talking about when launching an attack, but also to take steps to protect its own civilians from the dangers of hostilities coming from the other side. Iron Dome and the red alerts and the sirens and the bomb shelters and all of these defensive capabilities and infrastructure in Israel is a manifestation of exactly that. Now let's contrast it with Hamas, which provides underground shelter for who? Militants and rockets and military capabilities. the civilians, it puts on the roof to sort of set a contrast, right? It's not at all seeking to protect its civilians. It's using them as a pawn in the conflict. So Iron Dome is also relevant in that context. And it goes back to, you know, Daniel brought up the word asymmetry, which comes up all the time. There's a lot of asymmetries in this conflict. There's an asymmetry in law compliance, in measures to protect civilians, in military capability, and so on. The only asymmetry the world really seems to care about is an asymmetry of numbers. And the asymmetry of numbers, it has no, the law doesn't provide any analysis of that. It's fact, right? Asymmetry is all about fact, right? And rockets fired at Israel are intercepted by a defensive capability, and civilians can go into bomb shelters. Attacks against capabilities in Gaza, the civilians are left by their own leadership to fend for themselves. And that's one of the causes of that asymmetry. So I think Iron Dome is used as a symbol of a lot of interesting things in the conflict as well.
Thank you very much. On behalf of Elnet, I would like to thank you all for this very exciting conference, and I hope that we will have more. We think that we are very happy to partner with them. And I would like to give to Andrew Tucker 1 minute for his conclusion and to say hello and goodbye to everybody. Thank you very much all.
I'd like to thank the three speakers for taking the time. I think it's been amazing what you've been able to contribute. So thank each of you for making yourselves available. I think for me, you know, this is just showing, this is the tip of the iceberg. There's so much here that we need to be digging into and to be exploring and explaining. And I hope that this series will be a platform whereby expertise can be shared and can be broadcasted. So, and I encourage all of you who are listening and watching to, you know, even rewatch this and gather those little bits of gold that have been shared by our speakers, and generate the discussion with those around you, because it's not just the realm of lawyers, but we all have an opportunity to speak, and our goal is to help you to do that. So on behalf of thinc, thank you all. Thank you, Arié. Thank you, Elnet.